We are now in our question and answer session. So Lindy, I just want to check if you have any questions from the chat. I think we can start there. Anyone in the room with a question, please raise your hand and our mic will come to you. Lynn?
Thanks, Lita. We've got a question for Dani. Question is, how would you otherwise go after retailers dealing in the infringing articles if not cited in interdict applications? Can you still, or would you have to wait for the market to clear?
Given the conduct in this specific case, I think the landscape has changed. And I think in future proceedings, you might, the moment that one launches urgent interim interdict proceedings against the company that's got the registration and bringing in the product and distributing it, at that stage, I think retailers could expect letters of demand. And they will have to make a very early choice to either abide by the judgment in the proceedings between the disputing parties or face a joinder. And I think we will in future quickly see which way retailers and which position they take and which way they lean. And depending on that, I think practice will just adapt to whatever is the case. It is difficult. In the past, after a judgment, many retailers, if you had written letters to them, they would have returned stock and removed it from the shelf, because the act of, in patent term, there is a separate act of infringement on the retailer side. The fact that they keep an infringing product and continue selling it, each sale is an act of infringement. So once that is drawn to their attention that there's a judgment in respect of that product, in the past they returned the product and they didn't continue with that infringing conduct. And that's why I say it was in many respects quite a unique situation that we had in this Xaralto litigation.
Thanks, Dani, for that. I don't have a question for you, but I think you shared a little litigation tactic here, which I think is helpful. Good prep, witness who may perform a bit shakily on stage, but you can rely on good papers. I thought that was nice and clever.
Yeah, I just want to add to that, and this is something for patent people, and they often, when we litigate patent matters, our expert evidence is very important. I think it goes for all cases, but preparation of your expert summaries, people might often ask, why do we put so much effort in those? And experience have learned that fallback position on your expert summary, which you, at the start of the expert's evidence, you bring that in, you get him to confirm it, it's in the evidence, and you can rely on that paper afterwards. And that is very powerful, but takes a lot of prep and work before the hearing.
No, that's good. Thank you so much, Dani. Darren, I have a question for you. How will the Sky case play out in South Africa? How would it have played out? Would it have had the same outcome or different?
I think if you've got, sorry about the shouting. In South Africa, you've got 23, imagine 23 applications, 23 classes covered by an application, and it gets before a court. And imagine one of these tough guys on the right just saying you've got lack of bona fide intention to use, and Dani gets an expert witness and calls you for cross-examination. I think that guy's going to really struggle to show that they've got a genuine bona fide intention. I think if you look at the Sol, it's a very good question, because we saw that even with restaurant services last year with the Sol cases. So just to very quickly take you back, Chicken Licken's got restaurant services, not huge, it's just restaurant services, but yet they use it for takeaway outlets. And the judge refused on socio-economic rationale in the lower courts to enforce that trademark against a restaurant called Salsiflaki. And I think you're going to find, so I have a feeling that it would be, those trademarks would have been declared invalid, but that's just my view.
Thanks for that, Darren. Any questions in the room for any of our panelists? I've got a question over there. Adele. Okay.
Okay, so you've mentioned that the patent expires. So my question is the duration thereof, and also your trademark marks. Does that also expire? Yeah, so that's just mine.
So it's not a short answer. So when you look generally at an invention, if you apply for a patent for invention, that lifetime of that patent is 20 years. So that's the maximum term that a single patent can last. But for many types of products, they are covered by multiple patents because products are often developed in an incremental way. So you have an idea and you might file a patent for that idea. You might have a second idea. And I think a couple of years ago, there was an ad for Audi which claimed that they had more than 9,000 patents on a single model. So, but think about it, Daimler invented internal combustion engine and filed a patent for that at the end of the 18th century. Ford had lots of patents for the manufacturing process, but that is how products develop. You have the series of patents. So often products are protected by a series of patents. So one might expire on some aspect, but there might be other remaining patents on different aspects of that product. So yeah, that's the long answer. Someone else can deal with the trademarks. It's all
The trademark answer is much easier. It can live forever. So you have to renew it every 10 years in South Africa, but there's no limitation on the lifespan of a trademark.
Thanks, Gerard. Any other questions on the floor? Okay, I think I saw that hand first at the back, right at the back, the gentleman at the back.
Question for Gerard. So did the Supreme Court of Appeal overrule the Constitutional Court's decision on substantial economic detriment?
It's a difficult question because in terms of jurisdiction, it cannot do so, but it sidestepped the ruling and I think gave us more options to again look at enforcing 34(1)(c) despite the Constitutional Court ruling in Lafferty off. Interestingly, when the Supreme Court of Appeal in the Salty Cracks matter defined the application of 34(1)(c), it did not go to the Constitutional Court judgment, it went to Harms's judgment in the Supreme Court of Appeal and then just dealt with some aspects of the Constitutional Court judgment. But to my mind, it definitely put a different interpretation on it, and although it cannot overrule the Constitutional Court judgment, it certainly gave us scope for relying and enforcing well-known trademarks, where I think it was a pretty hopeless sort of a scenario for us before this judgment. So I think it did make a difference.
Lynn, I think you have another question there.
Peter, I think this question is similar to what you asked earlier, but I've got a question for Darren, asking, does the Skykick decision mean one may in future need to show a commercial justification before deciding and applying for trademark now, even before using the mark in South Africa? And if you can't or diversify, would that then be in bad faith?
Very quickly, I think it'll depend on this judgment, right? So we'll wait. You know, I very much doubt that you'd need to have a commercial justification for that in that type of way. However, you can't be someone. I mean, the example used was a person gets an MBA and has got optimism, full of optimism with his MBA, and he goes to register and applies for a distinctive trademark and covers all the goods and services. and he might have a present and definite intention, but doesn't have a commercial justification just yet for using. Is that enough? And I don't think it is. And it's probably somewhere in between. So I think you just need to show a present and definite intention, which is the current ruling. But to what degree, I think, is going to be the question. Is going to be the answer of this decision. I hope that answers your question.
Thanks, Darren. I think we're 5 minutes over the time. We need to get on with lunch. I'm feeling a bit hungry, certainly. But before we do, I'll give opportunity for one more question. Just one more.
My question is for Dani. In metallurgy, there's a debate going on between the discovery of a process, a physical feature which would facilitate metal extraction versus an innovation or a discovery versus a design of a process. Would you comment on any case law on where this has been an issue?
So, in patent law, if you isolate a compound for the first time that's useful, you're entitled to claim protection for that compound itself. So in your example for extraction, if you have some organism that you develop or isolate for the first time and protect it, there are ways to protect it. And then, yes, then the next step, and that's generally, there's always the debate in pharmaceuticals, and I'm going to use that example, but you can take it to your metallurgy example as well. Innovation, as I said, is incremental. Somebody isolates a compound and decides, okay, it's useful for something. They do lots of tests and find, okay, we can use this for alleviation of some particular disease or list of diseases. They file a patent for the compound. Now they start their research. Eventually they find out it works very well for something, but we must make a lot of changes to that. That's the invention that they file a patent for. So it goes on until eventually the last invention is made before the product is launched. And by the time you launch the product, there's this whole series of protection. So in your metallurgy example, you might be able to file patents on your basic invention, your first steps. And as you develop your process, you can file different patents on different aspects of that process, and that's quite common. So most things are patentable. But speak to your lawyer.
Excellent. Thank you, Dani. That now takes us into our lunch hour, but before we dash off, I want to mention that after lunch we will have breakaway sessions, and these will take place in this room, in the room next door, and the room around the corner. For that segment, I will hand over to my co-MCs, Cohen, Maureen, and Peter. So they will look after you for that breakaway session. As Kelly mentioned in her opening address earlier, our virtual audience will also be able to join the breakaway session. I believe that the links have been emailed to you for rooms 2 and 3, so you can navigate your way around those. If not, Lynn, can you please just put a link on the chat so that people can access it easily? Yes, but the survey, just to quickly, please start filling it in and rating our speakers. For those in the room, the survey is in front of you. Please be nice. Thanks. And for our virtual audience, the link will be shared with you shortly. But don't fill in when you haven't had the talk. Okay, don't fill in for the last panel discussion. Wait around and then fill it in after. So please fill it in as we go. We appreciate your feedback. I think that's all for now. We will step out into lunch. Our virtual audience, you're also welcome to take a small break, but please come back. We will reconvene in the breakaway sessions at 12:55 sharp. Thank you.